County District Attorney's Office is pushing to revoke the bond for a former YSL member.
They believe Antonio Mounk Tounk Sledge violated conditions of his plea deal when he testified in court last month.
Right. So in 2022, Antonio Sledge had a choice: up to 35 years in state prison or probation in exchange for his testimony about a series of factual statements. He chose that second option and acknowledged that better known as YSL had at least 3 members who committed crimes intended to increase the notoriety, street credibility, and reputation of YSL. Those statements also said Sledge personally knew that one or more YSL associates committed the murder of Donovan Thomas Jr. on behalf of YSL, and that after that murder, Young Thug gave him and other associates cash money to lay low. Now, the DA's office wants to revoke his bond because he tried to walk back some of those statements in court.
Number 8, true or false?
False.
Number 9, true or false?
False. YSL is not a gang. The crime that was committed, I don't think it was to do nothing with YSL, to boost the credibility of the street. There was none of that.
It says, use this one. That is the agreement that we thought we were executing on the
28th. Both you and Mr. Sledge are in person. Are you testifying now, or are you just recalling for me the testimony from previously during this ongoing trial?
Now, there was a big problem, and I noted in my testimony that number 8 on that version that got signed had been taken out, removed. All of a sudden it reappears and it's there. My client initialed it. Yes, it was tendered. My client initialed it. But ultimately, here's the problem. My client has always said he does not know who's responsible for shooting the victim, who he never was a participant or heard about planning the murder of the victim. And therefore, number 8 was put into evidence by Ms. Love to the court when it was a knowing statement. She knew that statement was false.
Here's the thing. You seem to be focused almost wholly, if not wholly, on, well, maybe there was a mistake with regard to factual assertion number 8. The issue that I see is that the state has not limited their petition to revoke probation to he contradicted or he refused to acknowledge during the trial that item number 8. It is the entirety of disavowing factual acknowledgments, etc. And what got disavowed under oath in this trial was far more than just item number 8. It was item number 3, item number 4, item number 5, item number 6, item number 7, item number 8, item number 9, item number 16, and then the part 5, sentencing acknowledgments, number 1, number 2, number 3, number 4, number 5, number 6, and the paragraph underneath asserting that he's read and that they're true and that he understands that he's had an opportunity to discuss it and he voluntarily enters into it, et cetera, et cetera. So even if we entirely disregard item number 8 of the factual acknowledgments, there are still however many other ones that added up to that the state is still relying upon. And I don't see how you get around, and maybe you have a way to get around the rest of it, and I'm certainly willing to listen. So does probation have a recommendation in this case?
Due to the last minute notification of this probation revocation, I would leave that up to the courts.
All right, well, I find there to have been a violation. What is the state's recommendation?
In full candor to the court, Your Honor, I'm going to leave it. The state is going to leave it in the full discretion of the court.
I believe in the petition for revocation, the request is that the entire 30 years be revoked. Is that right?
It's not the request.
Or is, oh, you're just telling me that's what he has at this point, although it can't be all of it, right? I mean, he's been on probation for at least a couple of years, and did he serve it? What's left?
He just started on December 8th of 2023. I think he got credit for the time. I think he was in for 2 years, so he would have 26 and change or 25 and change.
That would be 27 years, 7 months, and 8 days.
All right.
I understand the court's ruling that there is a violation. Ultimately, I guess to some degree, while it's not clearly akin to a substantive versus technical violation of probation, it is a non-violent, non-new offense kind of violation. And I would say if the court is going to violate my client, it would be more germane to treat it as a technical violation. I would ask the court treat it more as a technical. He has one grandchild on the way, one that just came early this year. So the point is, he has been staying out of the way. He's been complying with probation. I would ask the court to maybe consider if you want to put more restrictions and make his probation much more of a, not just something he's on, but something that now has more teeth to it. Because he's been working, he's been taking care of his family, he's staying out of trouble. Leave it in the discretion of the court, but we're asking again for a non-custodial revocation.
I don't view it as a technical violation or akin to a technical violation, considering the solemn oath that he took when he said that he understood every term within the plea agreement, factual acknowledgments, and sentencing acknowledgments, and understood and, in fact, orally answered that he understood when both asked by the prosecutor and the court at his plea hearing that a failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the fact that this particular violation is a non-violent violation. But I also appreciate the fact that some of the many reasons why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with which an oath in court needs to be taken. I actually view this much more akin to perjury, frankly, than a technical violation. And the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you have generally stayed out of trouble in, and I want to commend you for that. And I really hope that this revocation doesn't set you back. But we've got to take seriously the court system. So that's the sentence of the court. I find there to have been that violation. I'm revoking 5 years.
Possible for my client to turn himself in to make arrangements.
I think y'all knew when you came in here that this was a strong possibility. So no, I'm sorry.
Now, let's be honest. They hit him with the triple cross, man. This case does not surprise me, y'all. It's all over the place. How many people feel like he can be redeemed now that he got to go serve 5 years? Can he be redeemed for his testimony and then retracting his testimony and serving 5 years, violating his probation? Tune in.